A warm welcome to Legal Talks. Today, Advocate Dr. M. Sathya Kumar is with us. Welcome, sir.
Good evening, Don.
Sir, recently the state of Tamil Nadu has moved to the Supreme Court regarding the inaction on part of the governor on bills presented for his assent. Kindly, please brief on the same.
The government of Tamil Nadu filed a writ petition. The writ petition is numbered as 1239 bar 2023 in Supreme Court. And the matter came up for hearing. And the respondent of the petition was the governor of Tamil Nadu. Ram, if you see, governor from 2020 to 2023 has been consistently giving approval to many of the bills passed by the Tamil Nadu Legislative Assembly. But the point was, Tamil Nadu government in its petition said very clearly that more than 10 bills has been kept on hold or was being withheld by the governor for more than 3 years. This was the submission by the government of Tamil Nadu as part of the writ petition filed in the Supreme Court under Article 32 of the Constitution of India. Ram, if you go and see the statistics provided by the respondent, that is the governor's office of the governor. If you see from year 2020, 2021, that is 2020, 2021, 22, 23, total bills received from January 2020, they have tabulated very clearly. And in 2020, they have received 46 bills, 2020. They have given, governor has given an assent for 41 bills.
Out of 46.
Out of 46. And the government of Tamil Nadu, suo motu withdrawn 3 bills. So reserved for consideration of the Honorable President was 0 in that year. Assent withheld by the Honorable Governor was 2. And finally, under process, there was 0. If you see 2021, the total bills received was 41. And assent given by the Honorable Governor was 40. Subsequently, the bills withdrawn by the Tamil Nadu government was 1. And reserved for consideration of the Honorable President was 0. And subsequently, assent withheld by the Honorable Governor was 0 again in that year, 2021. And under process, again it is 0. In 2021, in the middle of the year, around May-June month, the new government gets formed under the leadership of Chief Minister Stalin. And if you see in 2022, in that year, Tamil Nadu Legislative Assembly passed 58 bills and it was sent for the assent of the governor. Out of the 58 bills that was sent to the governor's office, 44 got assent of the governor. And subsequently, one was withdrawn by Tamil Nadu government, suo motu, and reserved for the consideration of the Honorable Governor, Honorable President, was 7. So 7 bills were referred because governor has the power to refer the bill to the president in certain situations. And assent withheld by the Honorable Governor was 6 bills were withheld by the governor in that 2022. The bills under the process were 0. But however, if you check 2023, the total bills received by the governor, that is the bills passed in Tamil Nadu Legislative Assembly, was 36. And assent given by the Honorable Governor for the bills were 27 bills out of 36. And withdrawn by the government of Tamil Nadu were 0. And reserved for consideration of Honorable President was 2. Assent withheld by the governor, Honorable Governor was 2. And the total bills under process were 5. So if you check the total bills that the governor has got in the last 3 to 4 years, it is about 181 bills in total. 152 bills the governor has provided the assent. And withdrawn by the Tamil Nadu government, by suo motu withdrawn by the Tamil Nadu government were 5. Reserved for the consideration of the Honorable President were 9. Assent withheld by Honorable Governor were 10. And under process were 5. So if you see the statistics, as such the governor has not withheld all the bills of the Tamil Nadu government or the bills passed in the Tamil Nadu Legislative Assembly. Wherever he had the power, wherever he had certain doubts to be cleared, he had two options: either to send back the bill or send it to the refer the matter to reserved for the consideration of the Honorable President. But only few bills, roughly about 10 bills, were kept without being given assent.
10 out of the 182.
Out of 182. So the Tamil Nadu government as such, when they filed the petition, they said as though bills were kept forever pending in the office of the governor. But governor has only 10 bills were withheld by the honorable governor. It is withheld. And 5 bills were under process, whether to give assent or not to give an assent. It was under the process. So 10 bills, what are the 10 bills? That's very important to know. If you see the bills which were kept on withheld by the governor, the bill number 2/2020 was presented to the governor to amend the Tamil Nadu Fisheries University Act 2012, was sent to the office of the governor for his assent on 13 January 2020, when the erstwhile ADMK government was there. This was withheld by the governor. Second bill that was withheld by the governor was 12/2020 to amend the Tamil Nadu Veterinary and Animal Sciences University Act 1989, was submitted to the governor for his assent on 18 January 2023. That is in the current year. And the next bill that was presented to the governor, which was withheld by the governor, this bill number 24/2022, which was to amend the university's registration so as to allow the appointment of vice chancellor by the state government instead of the governor. Here is a bill which was sent to the governor, where it is replacing the power of the governor itself. Except for the University of Madras, was submitted to the governor for his assent on 28th April 2022. Subsequently, one more bill was also sent to the governor, bill number 25/2022, a bill to further amend the Chennai University Act 1923, was submitted to the governor for assent on 28th April 2022. Bill number 29/2022 was to amend the Tamil Nadu Dr. Ambedkar Law University 1996, was submitted to the governor for his assent on 16th May 2022. Subsequently, one more bill was also sent, bill number 39/2022, to amend the Tamil Nadu Dr. MGR Medical University Chennai Act 1987, was submitted for the assent of the governor on 16th May 2022. Ram, I am detailing all this bill to show why these bills were kept withheld by the governor. There are 4 more bills which was also withheld by the governor. That is bill number 40/2022 to amend the Tamil Nadu Agriculture University Act 1971, was submitted to the governor for his assent on 16th May 2023. Bill number 55/2022 to amend the Tamil Nadu University Act 1982, was submitted to the governor for his assent on 27th October 2022. The last 2 bills which were also sent to the assent of the governor is bill number 15/2023 to amend the Tamil Nadu Fisheries University Act 2012, was submitted to the governor for his assent on 28th April 2023. And bill number 18/2023 to amend the Tamil Nadu Veterinary and Animal Sciences University Act 1989, was submitted to the governor for his assent on 28th April 2023. Ram, if you see, governor out of 182 bills that was presented to him, in the last 4 years, even before the DMK government came to power under the leadership of Honorable Chief Minister Stalin, MK Stalin, those bills were primarily created by the governor, most of the bills. It is hardly 10 bills which were withheld by the governor, for which the government of Tamil Nadu was actually gone to the Supreme Court, has actually gone to the Supreme Court to file a petition to seek a clarification as to why bills were why bills were withheld by the governor. The power to withhold the bills it is provided as part of Article 200 of the Constitution of India.
What powers does Article 200 of the Constitution of India confers upon the governor?
Right, Ram. If you see Article 200 of the Constitution of India, it clearly says when a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council has been passed by both the houses of the legislature of the state, it shall be presented to the governor. It is presented to the governor, and governor shall declare either that he assents to the bill, he can either give assent to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the president. So there are three options available for the governor. First option, he can give assent to the bill. Second option, he can withhold the assent therefrom. Third, he can refer the matter to the president. However, if you see the proviso of Article 200, the governor may, as soon as possible, after the presentation to him of the bill for assent, return the bill if it is not money bill. So, point to be noted here, if it is a money bill, he cannot return, he has to provide assent anyway. Accordingly, the bill gets passed if it is a money bill. So, what is a money bill, finance bill and ordinance bill, we will see later. But if it is a nature of money bill, then the governor has no option other than giving an assent. It is a mandate provided under Article 200 of the Constitution of India. If it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as may be recommended in his message, when a bill is so returned, the House or Houses shall reconsider the bill accordingly. House or Houses shall reconsider the bill accordingly. And if the bill is passed again by the House, that is the Legislative Assembly, or Houses, with or without amendment, the amendment suggested by the governor, they may consider, or they may not even consider. And presented the governor for the assent, the governor shall not withhold assent therefrom. So that means, if it is not a money bill, and if the governor is returning it back to the state, that is Legislative Assembly, the Legislative Assembly, he may send with a message. That message can be taken into consideration, pass a necessary amendment to that effect, or they may not even consider the amendment to that effect and pass the bill in the Legislative Assembly, send it back to the governor. When it is sent back for the second time, governor has no option but to give the assent to the bill, but he has no option to withhold the assent to the bill. And by the way, the law is silent. That is, Constitution of India as part of Article 200 is silent. Whether referring to the president can be done or not for the second time. However, if you may see the proviso, second proviso added to the Article 200, assent to the bills, provided further that the governor shall not assent to, but shall reserve for consideration of the president any bill which in the opinion of the governor would, if it become law, so derogate from the powers of the High Court as to endanger the position which that court is by Constitution designated to fill. To protect the power of the High Court, the governor in certain matters can refer the matter to the President of India. Ram, if you see, if the bill is sent for the second time to the governor, governor has no option but to give the assent to the bill. However, the proviso to Article 200 of the Constitution of India is silent with respect to the second time whether he can refer this matter to the president
for his review.
One more point to be noted here is, the wording used here is bill returned to the Legislative Assembly. Bill is passed by the Legislative Assembly. Bill is presented to the governor. Governor can either give assent, or governor can return back the bill, or withhold the bill, or refer the matter to the president. These are the four options available to the governor. Here, the wording is, if the bill is returned to the Legislative Assembly, and the Legislative Assembly passes the amendments as sent as a message by the governor, can send back the bill to the governor, and governor has no option but to approve the bill. But however, the complication here is, if the governor has been withholding the bill for some time, and then subsequently sends it back to the Legislative Assembly, Legislative Assembly passing that bill again presents it to the governor, whether he has to assent the bill compulsorily, or again he can put it on hold. Again, whether he can withhold the bill is a question of law. Ram, this has been this Article 200 has been a very important provision under the Constitution of India to uphold the federalism with respect to law-making process with respect to state government.
You mentioned the phrase as soon as possible in the proviso of Article 200 of the Constitution of India. Does that phrase, the as soon as possible, provides any time frame within which the governor is to assent the bill presented for him?
Yes, Ram. Ram, if you see, as per Article 200 of the Constitution of India, it provides the phrase as soon as possible. If you go through Article 200 carefully, you will very well know, because many law students are viewing this interview. They have to be enlightened. If you see, as per Article 200 to the Constitution of India, assent to the bills, there is a main provision. There are two provisos. In this first proviso, it clearly says, provided that, I quote exactly the wordings of the Bar Act of the Constitution of India, Article 200. It says, provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message, or houses will reconsider the bill and specified provisions thereof, and in particular will consider the desirability of introducing such amendment. That means the intention of Article 200 as part of the proviso is that governor should, as soon as possible. It did not use the word called as early as possible. It is not using the word called as, it's using the word called as soon as possible. So here the as soon as possible is not defined under the Constitution of India. And this as soon as possible has been a part of the debate of the Constituent Assembly. Ram, if you see the debates of our founding fathers of the Constitution of India, every article of the Constitution of India has been put for debate. Similarly, if you see Article 200 of the Constitution of India, Article 200 of the Constitution of India, I have the Chronicles of Indian Constitution with me, and I would like to enlighten the viewers that Article 200 of the Constitution of India has gone through multiple phases of discussion. So as it stands today, the Article 200 as it stands today was put for debate in the Constituent Assembly. It is very interesting to note, Ram, that Article 200 had its origin as part of Government of India Act 1935. If you go and check Government of India Act as it brought by the Britishers before independence, you can check section 75. In section 75, it provides for assent to bills. Subsequently, this Article 75 was brought in the first draft constitution by the constitutional advisor as part of section 147. It was section 147, assent to bills. Subsequently, this was also carried through in the draft constitution by the drafting committee under the leadership of chairmanship of Dr. B.R. Ambedkar. And this draft constitution was put for debate before the president and chairman of the drafting committee on three important dates, Ram. Three important dates. I'm just trying to bring in the entire gamut of Article 200 to make the viewers understand that 200 has been put for constitutional debate. The question as to whether it should be as soon as possible, time frame has to be fixed, or there should not be a time frame, all those were discussed. And in these dates are very significant. 14 June 1949, 1st August 1949, and 17th October 1950. 49. Three important dates the Constitutional Assembly debates happened, and in that debate, two important representatives were debating about it. One, Mr. Sri Brajeshwar Prasad, who is part of the Constitutional Assembly, and Professor Shiban Lal Saxena were debating. In fact, if you look at Shiban Lal Saxena, he was more like saying that the governor should not have the power. But if you see, Shibam Lal Saxena is more towards providing powers to governor. But if you may see Brajeshwar Prasad, Shri Brajeshwar Prasad, who was part of the Constituent Assembly, this debate was happening for 3 days, and they were debating as to see whether Article 200 has to provide a timeline for the governor. Finally, they discussed, and to ensure the federalism should be there as part of giving an assent to the bill, they decided that the governor should be provided the powers of assenting to the bill in 4 options. Either he can assent the bill, or return back the bill, withhold the bill, or refer the bill to the president. These 4 powers were brought in. Now, it was not an absolute power for the governor to reject any bill. The entire reason is we are coming as a country together at that point of time, and democracy was to be safeguarded through blossoming federalism, especially cooperative federalism. Considering, because the entire reason that these debates were going on is to ensure that the state autonomy also should be provided for. Accordingly, in that debate also they wanted timelines to be provided. In fact, T.T. Krishnamachari, Sri T.T. Krishnamachari also debated for providing a timeline. However, this again came up for the debate later, sometime after independence, after we got the Constitution of India, in the year 1987, before Sarkaria Commission. And this is a very interesting point to be noted down, because it also provided for the timelines.
What was the legislative intent behind the phrase "as soon as possible" as enshrined in the Article 200 of the Constitution of India?
Ram, if you see Article 200, the entire legislative intent was to ensure that the bills which are useful to the public, people, see, at the end of the day, Legislative Assembly represents the will of the people. The will of the people becomes the bill of the Legislative Assembly. The bill of the Legislative Assembly goes for the assent to the governor. This was a process attempted to ensure there is a maker-checker control. The bills passed by the Legislative Assembly is also checked by the governor, and he had 4 wide powers, either to give assent to the bill, or return back the bill, or withhold the bill, or refer the matter to the President of India. These powers were provided because there is a maker-checker control within the system of legislative. Because the will of the people becomes the bill, and bill should also be given assent by the governor. The entire reason the wording "as soon as possible" was provided is to ensure that the governor should not delay. The party that comes to power remains in the power only for 5 years. The will of the people, it remains for the 5 years. And next 5 years, we don't know whether this party will come to power. So they have to prove that they are working for the people only by enacting the legislation that is requirement of the people. So if the governor is taking time, years together to pass a bill, then it will obstruct the work of the respective government in place which has come to power. So considering all those reasons, the Article 200 of the Constitution of India provided for the wordings "as soon as possible." But this was put for debate in Sarkaria Commission in 1987, Ram.
The Sarkaria Commission, in its report, has recommended a time limit of 6 months for the governor and 3 months for the president to act on the bills presented for them. So, how this recommendation of the commissions is expected to influence the decision of the apex court?
Yes, Ram. Ram, if you see Sarkaria Commission, which was way back in 1987, they recommended for the timeline as part of Article 200. And one more commission was formed under Chief Justice, former Chief Justice Venkatachalaya, wherein under his leadership, Commission recommended again for the timeline as part of Article 200. That means today the state government of Tamil Nadu has filed this petition in Supreme Court. This is not the peculiar problem that is arising only today. It has been a problem. It has been a point of debate. It's a question of law since the time the Constitution of India came. So, in these many years, there is no constitutional amendment at all. The question now is whether there will be a constitutional amendment that is going to happen shortly, that we have to wait and watch. But however, whether it is Sarkaria Commission, whether it is former Chief Justice Venkatachalaya Commission, or subsequently Punchi Commission was with respect to giving assent to the bill, it's all their stand was there has to be a timeline. They recommended, in fact, there broadly if you see all the commission's recommendation, I have tried to summarize it as part of 6 points. The first point is that it required prescribing a time limit, say a period for about 4 months, within which the governor should take a decision, whether to grant assent to the bill or reserve it for the consideration of the president. That is the first point of recommendation. Second point of the recommendation, if you harmonize all the 3 commissions' report, delete the words or that he withholds assent therefrom from Article 200 of the Constitution. In other words, the power to withhold assent conferred upon the governor by Article 200 should be done away with. That was the second observation provided by the commissions. Third recommendation, if the bill is reserved by the governor for consideration of the president, then there has to be a timeline for the president also. There should be a time limit is what the commission said, say of 3 months. They even given an example within which the president should take a decision whether to accord his assent or to direct the governor to return it to the state legislature or to seek the opinion of the Supreme Court regarding the constitutionality of the act under Article 143 as it happened in the case of Kerala Education Bill in 1958. Coming to the fourth recommendation of all these commissions, when the state assembly reconsiders and passes the bill with or without amendments, after it is returned by the governor pursuant to the direction of the president should be bound to grant his assent. It is the fourth recommendation of the commission. In the fifth recommendation, it said to provide in Article 200 that a money bill cannot be reserved by the governor for the consideration of the president. In case of money bill, he cannot withhold, but he can refer the same to the president. So the commission recommended saying, even in case of money bill, it can also not be referred to the president. The last important recommendation of the commission, Ram, in the alternative it may be more advisable. They have said to delete altogether the words in Article 200, empowering the governor to reserve a bill for the consideration of the president except in case contemplated the second proviso. The second proviso to Article 200 in cases where the Constitution requires him to do so. Such a course would not only strengthen the federal principle, but would also do away with the analogous situation where under a bill passed by the state legislature can be killed by the Union Council of Ministers by advising the president to withhold his assent thereto or just by cold storaging it. The above mentioned recommendations have been made by Justice M.M. Punchi Commission in Volume 2, Chapter 4 of Para whatever, 4.5.01 of its report on the point of role of governors and the president regarding their assent to the bills passed.
Coming to the political side of it, Mr. Rahul Gandhi recently in a rally participated by him had allocated the central government that they are using their majoritarian stake at the parliament to influence the governor to act upon their wish. So what's your view on this?
Definitely, Ram. Being a party in opposition, Mr. Rahul Gandhi, who is heading the Congress, was always in the spree of allegation on the centre, headed by Honorable Prime Minister Sri Narendra Modi. But however, this time the issue was very different. I think Mr. Rahul Gandhi has to watch this video to understand Article 200 of the Constitution of India. Ram, if you see, this allegation is just not the allegation of Mr. Rahul Gandhi, who is from Congress, but it is an allegation of India Alliance. Mr. Rahul Gandhi sets the tone at the top, and all the regional parties who are part of the India alliance goes on to file petition against the governors, following it up with the party led by DMK, which is in power today in Tamil Nadu, who was the first to file the petition against the governor office in Supreme Court. Ram, the entire Article 200 was not new to India. When Constitution of India was brought, when the founding fathers of the Constitution of India were debating about this Article 200, they had applied their mind and heart into framing the Constitution of India. And if they are using the word called as soon as possible for providing an assent to the bill, that means they would have given a lot of thought process into it. But I'm not saying it cannot be changed. But changes to the Constitution of India, the constitutional amendment has to take place in Article 200. Then what is the requirement for constitutional amendment? To amend the Constitution of India, 2/3 of the Lok Sabha, 2/3 of Rajya Sabha, and 50% of the state assemblies should pass the amendment bill to amend any article of the Constitution of India. And here, if the Article 200 provides for as soon as possible, and that does not provide any timeline as recommended by the commissions, that is the Sarkaria Commission, and then subsequently former Chief Justice Venkatachalaya Commission, then third is Punchi Commission. None of these, all these commissions provided, if you harmoniously read, they only provided for the timeline, for the governor as well as for the president. Considering it, if the timeline has to be brought in, constitutional amendment has to get through. But however, the issues surrounding governor and the head of the state, governor and the chief minister of the state, governor and the state assembly is not a new thing that's happening today only in Tamil Nadu. It's been a problem of many governments in the past. Even when center Congress was ruling, the Congress had gone to dismiss many of the state, many of the chief ministers of the state government. So considering it, in fact, Congress has been using Article 200, is my understanding in the past. So Rahul Gandhi making this statement, I can only see it as a political statement. Never, it's a constitutionally valid statement, as ever. So considering it, we have to see what will be the outcome of the decision of the Supreme Court in the days to come, because the matter got listed on 1st December 2023. I am keenly looking at the apex court decision than the statement provided by Mr. Rahul Gandhi, which has no relevance to the Constitution of India. So I am waiting for the judgment of the Supreme Court, the apex court, with respect to the petition filed by the government of Tamil Nadu as part of writ petition number 1239 bar 2023, which has got listed in the court number 1 in the last hearing. So considering it, we will wait and watch for December 1 to see what is the judgment that is going to come from the Supreme Court with respect to the petition filed by the government of Tamil Nadu. Ram, one thing is very clear. Out of the 3 organs of the Constitution of India, legislative, executive and judiciary, independence of the judiciary and power of the court is to decide on a matter. And Supreme Court being an apex court of the country, the matter is pending before them, and we have to wait and watch what will be the outcome. We have no one to decide what will be the outcome. So we have to wait and watch for the Supreme Court decision or judgment. So let's wait for it, which will be anytime be passed in the month of December.
And then, sir, do you think that the opposition-led states are politicizing the post of vice chancellor in the state-owned universities because all these are opposition-led states, and they are just wanting to transfer the vice chancellor post to the CMs of the respective states? How do you see this?
Yes, Ram. See, education being a subject which is part of the concurrent list. See, we have 3 lists again in the Constitution of India. One is the union list, second is the state list, and third is the concurrent list. So education being a concurrent list, both the union government as well as the state government can pass the legislation according to their powers in hand. However, one thing that was always been a practice, the governor has always been a chancellor, and he had the power to appoint the vice chancellors of the respective universities. Here is a bill before the governor of Tamil Nadu where they've asked for his assent, wherein bill number 24 bar 2022 to amend the university's legislation so as to allow the appointment of vice chancellor by the state government instead of the governor. Here is a bill presented to the governor where he is expected to give the assent to taking over his own power. So how this could be except for the Madras University? So it was submitted to the governor, and the petition that they have filed with the Supreme Court, they have placed this bill also to say that the assent is not provided. It has been withheld by the governor. So considering it, what we have to understand, whether it is unconstitutional, the question here is shifting of the power from governor to respective chief minister of the state, that is the legislature, head of the legislature, whether it is whether it can be upheld constitutionally. Answer is yes. This bill is being passed by the state legislature, and accordingly the state legislature passes this bill, and if the bill is returned back by the governor, again it passes, and second time it comes to the governor. He has no option but to give the assent. But the point to be noted here is, in case of Tamil Nadu, governor has withheld this bill. So he has sent back to the legislative, and again the legislative has passed this and is sent back to the governor. That will be considered as a fresh bill.
Fresh bill.
So we have to wait and watch what will be the outcome. The question of law here is, if the bill is withheld and subsequently sent to the state assembly, again they pass it and send it back, whether it will be considered as a fresh bill or it will be a bill considered to be sent for the second time, an automatic approval, de facto approval has to be provided by the governor. So these are the questions of law that we have to look forward in the decision that is going to come up shortly in the Supreme Court round.
What, according to you, could be the next move of the governor?
Governor as such, he has been executing his duty as enunciated under the Constitution of India. With respect to governor, the bill comes to him, he has the power to give an assent, he has the power to withhold the bill, he can refer the matter to the president, or subsequently return the bill with a message so that the amendment can be carried out by the legislative assembly. I think he has been executing his powers in the last, especially in the last 2 years, sparingly, and also ensuring that the bill gets the right kind of a legal, he gives a assent, but he upholds the legality of the respective bill. Ultimately, if it is not constitutional, again it will go back to the courts for the checking of the constitution through writ petitions. I think maybe the governor can speed up the process of giving an assent or returning it back or withholding or referring to the president, and which is the discretionary power of the governor as per Article 200. So we have to wait and watch what could be the outcome of the Supreme Court judgment that is going to come up shortly, anytime in the month of December. The next hearing is posted on December 1st. But however, we have to understand, out of the 3 organs of the Constitution of India, legislative, executive and judiciary, judiciary is the independence of the judiciary, and power of the court is the power of the apex court is independent, and accordingly we have to wait and watch what will be the outcome. So the statement of Rahul Gandhi or anybody's statement which is political has no relevance with respect to the court. So accordingly, it's a Constitution of India which is prevailing as of today, says as soon as possible. So we'll have to wait and watch now.
Thank you so much, sir.
Thank you, Ram.